Good morning, class. Today we're going to start our discussion on offenses against the person. The first one we're going to look at is homicide. Now, what is homicide? Homicide is the killing of one human being by another human being. And homicide could be either lawful or unlawful. Now, what is lawful homicide? Lawful homicide is a killing that is authorized, justified, or excused. Now, example of lawful homicide is where the punishment of death sentence is passed on an accused person that is condemned. Then that is an example of an authorized killing. Now, also an example of justified killing is in self-defense, where somebody plans trying to kill you, you try to defend yourself, you fight for your life, and in the process, the other person dies. That is a justified killing. Now, excused killing is a killing that occurred out of independent of the will of the perpetrator. For example, if it occurred by accident or by mistake, that's an example of excused killing. They are all lawful homicide. Now you can see sections 32, sections 32, 286, and section 306 of the Criminal Code. These sections actually state all this kind of lawful homicide. Now, let's go to unlawful homicide. Now, since you know that lawful homicide is the killing of one human being by another human being, unlawful homicide is the killing of one human being by another human being without any lawful excuse and in breach of the criminal law. So, examples of unlawful homicide, we have murder, manslaughter, infanticide, etc. But our discussion will be centered on murder and manslaughter, which is because this is what usually occurs in this part of the country, in Nigeria. Now, when we talk about unlawful homicide, unlawful homicide is the killing of a person, a human being, by another human being without any lawful excuse and in breach of the criminal law. Now, a killing must be the causing of the death of another by another human being, either directly or indirectly by any means. That's what killing means. Now you can see section 308 of the Criminal Code. Now, so when we talk about killing, it must be a person that is being killed by another person. The shooting of a corpse, for example, somebody that is already dead does not amount to murder. So if the death of the person killed does not occur, if the person we are talking about has already been dead, you can't say that is murder. Now you can see, and also death must have occurred between a year and a day from what you did, from what the accused did, to the disease before you can say that it's actually murder. If not, it is not murder. Now let's go straight to, it's not unlawful homicide. Now let's go straight to murder. Section 316 of the Criminal Code actually makes provisions for the various ways in which murder can be committed and which would amount to unlawful homicide. The first one, section 316 subsection 1, says that murder is committed if the offender intends to cause death to the person killed or to another person. Then it is murder. For example, if he intends to kill B and he actually shoots B either by stabbing or poisoning or whatever, and B eventually dies, it is murder. Or if he intended to shoot B or do kill B and then the person that was killed was another person, that is C, it is still murder. The fact that you didn't intend to kill C is B you wanted to kill, it doesn't matter. So far you had the intention to kill a human being, it will be murder. Now you can see the case of Basoyin against Attorney General Western State. In that case, the accused intended to kill his wife. The wife was backing their child and she moved and the machete hit their child and the child died. The court held that it was murder, regardless of, he didn't have the defense of saying that he wanted to kill the wife and it was the child that was killed. So in this section, when we talk about murder, whatever, there must be intention. Intention to kill or cause death is very important. Intention to kill is very important. So you must be able to prove that the accused actually had the intention to kill the deceased, which was the decision of the court in Makari against the state. Now, intention could be actual, we have said this before, or inferred. The court can infer it from the weapon used, from the part of the body that was hit. Now, in Idagbo against the state, the accused hit the deceased on the head with a shovel. Now, the court held that he had intention to kill because shovel is not a cane and the head is a delicate part. So why will you use shovel to hit somebody on the head? Also, in the case of Igbo and the state, the accused actually used iron chains to hit a 10-year-old boy on the head and he died. The court held that he had intention to kill. Also, in Adamu and Kano, here the deceased stabbed the accused stabbed the deceased twice on the tummy and at the back. The court held that he had intention to kill. The court also looks at the degree of force used or the quantity of poison administered to determine whether there was actually intention to kill or not. The second provision is that section 316 subsection 2 says that if you add the intention to cause grievous bodily harm to that person or to another person, then it is murder if the person eventually dies. Now, grievous bodily harm is not just causing injury to somebody, it's a category of harm that is most likely in most situations leads to death. Section 1 of the Criminal Code actually gives a concise, a comprehensive definition of what grievous harm is. It says that it's something that is dangerous harm. You intend to maim that person, or to permanently or seriously injure the health of that person, or to even cause permanent disfiguration to the health of that person, cause serious and permanent external or injury to the external or internal organ, members or senses of that person. So it's a kind of injury that is on a level of its own that most of the time leads to death. Now, in Hymen and DPP, in that case, the accused was jilted by her lover, and then she went to set the lover's the other woman's house on fire. That's her rival, with her 2 children in the house. The court held that she intended to cause grievous bodily harm. Because they eventually died, the court held that it was murder. For you to know that people were in the house and you set the house on fire, it means that you intended to cause grievous harm. We can also see the case of Akron and the state, where the accused actually kicked a woman of a 5-month-old pregnant woman in the tummy and she died. The court held that he intended to cause grievous harm. So intention can be inferred from the weapon used, from intention of the accused to kill or cause grievous bodily harm must be present. If the intention is not present, the court will hold that it's not murder but manslaughter, which also happened in the case of Queen and Akobi. In that case, the deceased wanted to test his juju that he used, that if anybody shoots him, the gun will not penetrate. And he told the accused to shoot him. The accused didn't know that there was bullets in the gun, and he did, and he eventually killed the man that had juju, and the juju apparently didn't work, and he died. The court held that he didn't have the intention to kill, that it was manslaughter. Now, let's look at the third scenario where murder can occur. Section 316 of the Criminal Code, subsection 3, says that murder can occur. It is murder if the killing occurs by an act done in the prosecution of an unlawful purpose. So in trying to commit an offense, if you do an act which leads to death, which endangers human life, and it eventually leads to death, you'll be guilty of murder. In the case of DPP and Beard, the accused raped a woman, and during the rape, he held the woman's throat and she couldn't breathe well, and she died. The court held that he was guilty of murder because in trying to commit an offense, he did something that endangered the life. What endangered the life was holding the throat of the woman, and the act that he was doing, the offense he was trying to commit, was rape, and that it was murder. You can also see the case of R and Namiri. Now, the fourth scenario is in subsection 4 of section 316 of the Criminal Code. Now, the section says that it is murder where the accused accused inflicts injury on someone which leads to death in the attempt to facilitate the commission of an offense, or in the attempt to facilitate the flight of an offender that has already committed an offense. So if you try in the process of facilitating the commission of an offense, grievous bodily harm is caused to somebody which leads to death, or in the event of facilitating the flight or escape of another person that has committed an offense, grievous harm is caused to another person, then it is murder. It is immaterial that the accused did not intend to cause death. For so far what you did was supposed to cause grievous bodily harm, then it is murder. You can see the case of Haran Atai, where he was trying to rob a shop, and then he met somebody there. He didn't know he was going to meet somebody there at that time, and he stabbed the person to death, and the court held that it was murder. Also, another scenario is subsection 5 of that section 316. It says that it is murder where death is caused by administering a stupefying or overpowering things for the purpose of facilitating the commission of an offense. That is in section 316 subsection 4, or for the purpose of facilitating the escape of somebody that has committed an offense. So it doesn't mean that you just used a knife or something. You can also use poison. Once you use poison for this purpose in section 316 subsection 4, it is murder. And also finally, it is murder in subsection 6 of that 316, where death results. It is also murder where death results, where the accused willfully stops the breath of the person to facilitate the commission of an offense. So if you willfully stop the breath of somebody to facilitate the commission of an offense, it is murder. Like in the case of DPP and Beard, Supra, where he was trying to rape a woman and held her throat to stop her breath. That's to facilitate the commission of an offense, then it is murder. So those are the circumstances in which it would amount to murder under section 316 of the Criminal Code. Next class will start with the requirements of the offense of murder. So please stay safe and read your notes and download this video. Thank you very much.